Hello. I want to welcome you all here. And in addition to the folks in the room, I really appreciate you being here. We have around 150 people online, and welcome to all of you as well. This is a speaker in our Green Bag series. The topic here is Reflections at CEQ. I'll say a little bit more about our speaker in a moment and give a little context to the topic. But first, let me just say welcome and thank you to all of you for being here. I'm Brig Daniels. This speaker series is a series that we have going on all year. Our next event is November 7th, and this is a big one. It's our 20th annual Young Scholar Lecture. Joshua Macy, who's Associate Professor of Law at Yale Law School, he'll be here to talk about regulating public utilities. We also have a few other things going on in November. You could look at the website, the Stegner Center's website, for more information if you're interested. So to introduce our speaker, I was mentioning to my class before just right before I got here, that it is a real shame that so many people within our law school community don't have a chance to learn from John Ruple. John is a research professor with the Stegner Center and has been for some years. But more recently, he has been with an organization called the Council for Environmental Quality, CEQ. CEQ is a very unique agency in that it's actually housed within the White House. It was a surprise to no one who knows John Ruple's work that John was asked to join the Biden administration and work for the Council on Environmental Quality. He, for years before the Biden administration took office, had been kind of thinking about what would the world look like if there was an administrative change. What kinds of questions should the new administration be looking at? And as soon as the transition team started looking at this issue, they realized that John was going to be a critical team member for the administration. He, during his time at CEQ, I'm not sure how much he can talk about the specifics, but he dealt with issues related to public land management and preservation. He dealt with mining law. He dealt with critical mineral supply. He dealt with mining pollution. He dealt with transboundary pollution and water control. And of course, he dealt with NEPA. NEPA is something where he's written on for years, and it is administration of NEPA to the extent it exists within an agency itself. It is CEQ. They are the entity that comes up with the regulations and the guidelines that govern NEPA. At any rate, John is an accomplished scholar. Everywhere I go around the country, other law professors are telling me how lucky we are to have John. They may have read some of his work in journals such as Environmental Law, the Columbia Law Journal, Berkeley's Ecology Law Quarterly. But regardless of where they've read his work, every time they do, they find a very careful thinker who is working at the cutting edge of issues that matter. I would like you to just one note here is the Q&A section. To ask questions, whether you're remote or person, we're going to be using Slido again. So if you go to slido.com, it's #Stegner. I think that's right. It's not on these notes. I think that's correct. Is that right, Jan? I think that's right. So it's slido.com #Stegner. You can put a question on slido.com #Stegner. and we'll ask those questions that are in the queue. If you like a question, if you don't even ask a question, but you like a question that another person's asked, you can always upvote that with the icon, the like icon. I'll be the one moderating the questions. Until then, we'll have the treat of listening to John Ruple. Please welcome John.
Thanks, Brig, and thank you all for coming out. This is fun. As Brig said, I'm John Ruple. I spent the last couple of years at the White House Council on Environmental Equality. I was in the Office of General Counsel, and Brig asked that I come and kind of talk to you all about what we did over the last couple of years, or what I was working on. So what I'd like to do today is talk real briefly about what the Council on Environmental Equality is, how it fits in the federal government and what we do, and then talk a little bit about one of the projects that we worked on while I was fortunate enough to be at CEQ. And it's a project that will hopefully be of some interest to all of you, because there's an opportunity for us to build on some of CEQ's work there that we'll talk about in a minute, and then leave the rest of the time for questions. I love that there's so many students here, and see what you're interested in talking about. So CEQ, or the Council on Environmental Equality, is part of the Executive Office of the President. So it is situated in the White House. It was created in 1939 by President Roosevelt. Basically, you can kind of see some of the other offices that are part of the EOP, Council of Economic Advisors, Domestic Policy Council, National Security Council, things like that you've probably heard of. Maybe some that at least for me, I was less familiar with, like the National Space Council. But kind of the common thread or the common theme here is these are offices that generally work on cross-cutting issues that involve multiple departments, issues that really don't fit well in a single bucket. So think of things like climate change. Obviously, EPA would be involved, but so is the Department of Energy, so is the Department of Defense, because climate impacts can be a threat multiplier. Also, the Department of Transportation is also heavily involved, because transportation impacts climate. Just about everybody has some kind of nexus to that challenge. So we're working across agencies on problems like that. And often, the overarching goal is to develop and implement policy initiatives on behalf of the administration. So a little more specifically, CEQ, it was created January 1, 1970, when President Nixon signed NEPA, or the National Environmental Policy Act, into law. And basically, the purpose there is to advise the president and help the administration develop policies. Also to assist in implementing those policies. Again, there's some cat wrangling that goes on there if we're talking about issues like environmental justice or climate change, or the energy transition. Obviously, that involves wide-ranging folks within the federal government, and we're often working across those agencies and across bureaus to move towards that common goal. And then fourth, CEQ is involved, as Briggs said, in implementing NEPA, the National Environmental Policy Act. So those of you that have had administrative law or environmental law, you're going to recognize NEPA as the law that requires federal agencies to consider the impacts of their actions before moving forward. So it's the law that triggers an environmental impact statement or an environmental assessment or some other similar kind of review. And CEQ is in somewhat of a unique position in that we promulgate the implementing, or CEQ, I can't say we anymore, but CEQ promulgates the implementing regulations that direct federal agencies and how they fulfill their NEPA obligations. So it's kind of a unique position in that CEQ is drafting regulations that apply to all federal government agencies rather than just internal. So this was my boss, Brenda Mallory. She is the chair of the White House Council on Environmental Equality, and just phenomenal. Brenda had served about 20 years in the EPA in their Office of General Counsel. She rose to be the highest career official at EPA, the chief operating officer for the Office of General Counsel under the the Obama administration, she was asked to be general counsel for CEQ. And then after President Obama left, she left to be director of regulatory policy at the Southern Environmental Law Center. And just a brilliant person, a brilliant leader. But when I came on and talked to Brenda, kind of the task we were given across CEQ was to be in every meeting. The sense was, at least the direction from Brenda, was that every issue is environmental at heart. It's likely to touch on air, land, water, wildlife, the kinds of environmental resources that CEQ is charged with considering and developing policies around. So the charge was big, and I think it's important to recognize that that's an approach that can change pretty dramatically from administration to administration. The Biden administration and Brenda, they leaned in, and they were pretty aggressive in saying we have a broad mandate and we're going to engage as broadly as possible on that. In prior administrations, CEQ has had more of a deregulatory role. It's been involved more on the rulemaking side with respect to NEPA, but here we had more of a policy focus, a little broader engagement. A couple other things about CEQ. It's not a regulatory agency. It's not like the EPA. It doesn't issue permits. Its power is soft power. Its power is the ability to convene other agencies, other interests, and bring people together and hopefully wrangle those cats. So aside from promulgating regulations that set forth the process for implementing NEPA, it's really more of a soft power. And any other final point I'd make is that it's a small office. At least it was small when I started. When I started, it was about 45 people total. And at that point, I think we were the smallest office in the EOP. It grew over time, but still, given that mandate, we had about 100, and when I left, about 125 people, including interns. And the Office of General Counsel was about 15 people. So it was not a huge office, but a lot of opportunity. And I'd also say, because so many of the folks that are at CEQ are political appointees, we also had a number of people that were on details, either from other agencies or like me from academia. But basically, this will give you a little bit of a sense of what the structure is. The key part here is we had about half a dozen different policy teams dealing with environmental justice, NEPA, conservation, climate, and so forth. The Office of General Counsel, we were typically assigned to work with one of those policy teams. For me, that meant most of my time went to the lands team on the conservation side. But let's talk about kind of what we did, some of the projects we're involved in, and why that might be of interest to you guys moving forward. And when Brig originally talked to me and said, would you be interested in coming out and talking about what you worked on, my thought was, sure, let's talk about Emmett Till and Mamie Till-Mobley and the national monument that's named in their honor. That it might be interesting to tell their story a little bit and talk about the legal issues that were involved in that designation and the process. But over the last couple of weeks, my colleague Jamie Ploon, Jackie Morrison and I, we've been talking, and there are things on the horizon that I think might be of more interest to you. So I'm going to take a little more of a forward-looking approach on this and talk about water quality concerns that involve hard rock mines in Canada that drain to the United States. So the photo on the screen, that's the Mount Polley mine in central British Columbia. If, I don't know, can you see my cursor? Oh, okay. This is a tailing pond. So when you have a hard rock mine, the miners pull the ore out of the ground, it gets crushed, and they then have to separate the target mineral from the overburden, from the carrier rock, the other things that come out of the ground at the same time. So it's a mechanical process, it involves chemical treatment, and all of that material, those tailings, get put in a pond typically. So that pond will contain kind of a slurry of water and those crushed tailings, unrecovered minerals, and the chemicals that are used in that leaching process. So oftentimes cyanide if we're talking about gold. And here you have the Mount Poly mine tailings dam. And as you can see here, there's kind of there's a big hole in it. Back in August 4th of 2014, the dam failed and it released the tailings from this dam. It was about 25 billion liters of water and tailings that ran downstream. So to put that in perspective, if you imagine an Olympic swimming pool, now imagine 10,000 of them, filled not just with water and mud and all of that slurry, but other things along with it. It was about 134 tons of lead, almost 3 tons of cadmium, and more than 2 tons of arsenic were released downstream. And that's obviously a concern if you live downstream or you represent downstream constituents. So I'd like to talk a little bit about the Elk-Kootenai watershed, which is a project that CEQ worked on quite a bit while I was there. Just to orient yourself here, obviously the Western United States, the US-Canada border here. This is British Columbia, Alberta, the black line here, that's the border between Alberta and British Columbia. And if you look at this blue line here, that's the Columbia River. So that's the largest river on the West Coast. It's the lifeblood of the West Coast. We think about the Colorado being the lifeblood here in the Southwest. This is the equivalent. It is absolutely crucial for hydropower development. It's an absolutely essential route for shipping and barge traffic. It is historically the spawning ground for at least 5 species of salmon plus steelhead. It has tremendous cultural, economic, and importance to the region. I mean, I don't think it's an exaggeration to say that it's right there with the Colorado or the Mississippi. It's one of the big river systems in the West. Now the purple river here, this is the Kootenai. And it's the second largest tributary to the Columbia by volume of water. It originates up in British Columbia, flows down into the U.S. where it's held back into Lake Koocanusa. It's held back by Libby Dam. Water is then released out of the dam, flows back, through Montana, Idaho, up into Canada again, into a second reservoir, and then it's released from there into the Columbia River. And we're going to focus more on the Elk River, which is a small tributary to the Kootenai. And we're going to do that because it's really important. And what's happening up there is significant. So the black lines here, these are the boundaries of the watershed. So if you think of the watershed in simplest terms, if rain falls or snow falls on the ground, all of that water is going to melt and it is going to drain down the Elk River. So whatever happens in this watershed will almost certainly impact water quality along that river. The yellow here, these are coal-bearing geologic formations, areas that have very rich coal resources that are economically recoverable. And you can see there's a lot of that in the watershed. The orange, these are operating coal mines. And then there are a number of red dots here that show proposed mine expansions. So we're talking about really big mine operations here. Mining in the Elk Basin began around 1897, and it really picked up in the 1970s. So it's mining for coal, but not necessarily the coal you might think of. It's not coal that's burned to produce power. It's coal that is used to make steel. So it's metallurgical coal. It's largely imported to Asia and used to build steel. And there's a lot of mining going on up there. About 25 million tons of coal are produced annually out of these mines. It's about 80% of all the metallurgical coal that comes out of Canada. And it produces about $5 billion in economic value for the province of British Columbia. So it's a pretty significant chunk of money with a significant impact on the Canadian economy. And as we'll talk about in a minute, potentially very significant impact on water quality. And as this implies, these are big mines. These are not small dots. The mine you're looking at here is Lime Creek, which is this guy up here, one of the kind of mid-sized mines in the area. If you look carefully, you can see there are a couple of mine buildings in here, and if you have really good eyes, you can see some of the large heavy equipment in the mine operation itself. These are open pit, mountaintop removal, valley fill mines, where they literally come in, take the top of the mountain off to remove the coal, move that mountaintop over into the valley. The scale is significant. These are comparable to what you see across the valley with Bingham Canyon. And again, 5 operating mines, 4 proposed mines, 1 that's in the closure process. So why is this an issue for the United States? It's an issue for the US because we live downstream of the Elk Valley. Because as these coal resources are uncovered, as rain falls on them, as they oxidize, they release selenium. And selenium it can be toxic depending on the dosage. So what you can see here are water quality monitoring points for selenium at different geographic places. The yellow here, or the orange here, this is at the bottom of the Kootenay watershed. There's really no coal mining that occurs up here. This is a largely intact and fairly pristine watershed. So this gives us a baseline. Our baseline is that, normally we expect to see about 0.8 micrograms per cubic liter of selenium coming down here. Well, if you look right below these coal mines, we're seeing about 100 times that. We're seeing about 10 micrograms per cubic liter. So 100 times our baseline value. And if you keep running down the watershed, if you go down past our first major reservoir here, think of it as a big settling pond that allows heavy metals, materials, and sediments to settle out. You keep rolling down here another couple hundred kilometers, and you go back into Canada. We're still seeing values, in the, about 4 to 8 about 0.8 micrograms per cubic liter here in the most recent sampling. So that's after settling ponds. If you go through another reservoir and then you go into the Columbia River, we're still seeing elevated values, in the range of what's that, about 2.0 micrograms per cubic liter. So significantly elevated a long way downstream. And that matters for the US because, it's far exceeding water quality standards. And I apologize, I didn't have a good graph for this, but what you're seeing here, the dots represent different samples of water quality at various points. This is in Lake Koocanusa. This is right across the border in the lake itself. The green line represents Canadian water quality standards or British Columbia water quality standards. The purple, or this line here, this represents US and Montana state water quality standards. And it's kind of cropped off here, but the takeaway is that since at least 2000, we have not seen a water quality sample that is below those standards. So everything that we're finding in the US at this point exceeds water quality standards. And that can be bad news if you're a trout, because selenium does a couple of things. It can affect formation of the gill plates, the part of the anatomy that covers the gill that allows the fish to take oxygen out of the water. It can also impact the neurodevelopment and cause spinal deformities. Both of these, of course, lead to increased mortality of trout. And the big concern is less with these deformed fish, but the prospect of a collapse in the size of the fishery, because at some point the fish simply will not be able to reproduce in adequate or effective levels, or at levels that are sufficient to continue the current population. Trout are also a significant part of the diet for some of the downstream tribes. So that's a concern if you happen to be a member of the Ktunaxa Nation and you're thinking about this as a subsistence resource, or if you're thinking about it as a cultural resource, if it's part of your identity. The good news, though, is that when we sample the tissue from these trout, we find that there's not a lot of selenium in the tissue. So eating this fish, assuming you find it appetizing, probably isn't going to make you sick. The bad news, though, is that obviously there are a lot of folks that aren't going to be very interested in eating the trout that come out of this system. There may be a population collapse, and there are other fish in the system that are uptaking the selenium that do pose a potential health risk to downstream tribes or downstream consumers. Primarily, there we're talking about the Ktunaxa Nation, which are 6 different nations that traditionally have homeland that crosses both the United States and Canada. So here's roughly where our mine is. And you can see we have four First Nations up in British Columbia, and then we have the Kootenai tribe of Idaho and the Confederated Salish and Kootenai tribes down here in the US. So they have a significant stake in what happens in this watershed. For decades, the US, the tribes, First Nations, they have all been pushing on Canada and British Columbia and Teck Resources, the owner of all of these mines, to say you've got to do something. You've got to reduce the selenium concentrations because as you saw, there was an upward trend in water pollution problems. But there was no traction. For at least 15 years, we were unable to make much progress there. And it's a tough challenge because kind of master the obvious, right? The EPA doesn't get to go into Canada and set water quality standards or revoke mine permits or any of those things. So we have to find other ways to crack this nut. And the legal handle we worked with is the Boundary Waters Treaty of 1909. So a treaty between the United States and Canada. And to kind of boil it down, the TLDR on this is neither country is supposed to allow pollution to flow across the boundary to the extent that it would cause injury or to health or property of the other nation. So that's kind of the bottom line here. And a quick takeaway point, the 2 signatures to this are the United States and Canada. So the Ktunaxa Nation was not a party to this treaty. Under the treaty, the treaty itself creates an international joint commission, a body made up of 3 representatives from Canada, 3 representatives from the United States, and their task is to work on these kinds of water quality issues, to investigate, monitor, and recommend actions when a dispute arises. But a couple of takeaways here. First, they have to be asked by the governments. So they don't have the authority to step in of their own initiative when a problem arises. Here, the IJC was very concerned. They wanted to engage, but they had to be asked in. Second, again, the Ktunaxa Nation isn't part of the treaty, so they couldn't invoke the treaty protections. Third, yes, you can have the United States or Canada make a unilateral ask, and we talked about this. There was a lot of thought that went into the viability of a unilateral ask, and the decision was no, it doesn't make any sense. If the United States submitted a unilateral reference, BC likely wouldn't play along. They wouldn't have an incentive to contribute funds to develop the study protocols or to accept the outcome. So it was kind of an empty threat. And then in the end, the IJC doesn't have any authority to force action. So what do? We managed to break through the logjam. We got the first reference. It's called a reference, that process of moving a recommendation to the IJC. We got the first reference in about 15 years to the IJC on this matter. And one of the key pieces was a joint statement that was issued by President Biden and Prime Minister Trudeau back in March of 2023. The key part here is they agreed to reach agreement to reduce and mitigate the impacts of water quality, water pollution in the Elk and Kootenai watershed. So this was a huge piece. It was snuck, not snuck. It was in a joint statement from these two governments, and it may have been, at least in my opinion, the single most important piece of the process, because when we were sitting down around the table with Environment Climate Change Canada, Global Affairs Canada, the State Department, the EPA, the White House, and Canada was trying to pull back and say, not quite so quick. We're not so sure. Maybe this is just about monitoring. Maybe this is about information sharing. We were really able to push back aggressively and say, no, it's about reducing and mitigating impacts. It's about protecting people, and tribes need to be at the table. And we are on the clock. We've got a deadline here. And it was really useful in being able to keep the process moving forward. So just food for thought. Sometimes those PR pieces can be very, very useful. PR is probably the wrong way to frame this, but those kinds of public statements can be very, very useful. So jumping forward, we did manage to get a reference to the International Joint Commission. The takeaway here is the IJC was going to help in doing two things. One, setting up a study board that would help understand the scientific questions, the nature of the resource, the laws involved, how all of those things work, as well as a governance body that would then have the authority to represent the individual actors in British Columbia and in the United States, and hopefully move forward with a solution. So this was the culmination of about 2 decades of effort, and really nobody thought we were going to succeed, but we did, which was very, very exciting. So what changed? How did we kind of break through this moment? And I think two things happened that were really essential to our success, or really critical to our success. The first was a big spread in the New York Times that appeared in July of 2023. So if it's the online version, this was the banner. This was the first thing you saw, this multi-page article with lots of graphics showing mining in the Elk Basin and talking about downstream impacts to the US, talking about Canadian and BC and Trex intransigence. And that really got the phones ringing. We were already hard at work at this point, but it really elevated the issue. The second thing that happened is that Teck Resources, the company that owns all of those coal mines, both the existing and proposed, had been in talks to spin off those assets, to spin off its coal mining assets to other companies. And they announced a tentative agreement with Glencore, a large Swiss mining company, to sell all of their metallurgical coal assets. So everything in the basin would go away. 77% of it went to Glencore. The other remaining 23% went to Nippon Steel. And I think this, frankly, it terrified Canada and British Columbia. Teck does not have a great reputation as being a progressive mining company or a company that really leans into resource stewardship, but they're a Canadian company. They're headquartered in Vancouver. And I think the Canadian and provincial government looked at them and said, we can work with Teck. We have access to them. We have leverage on Teck that we don't with a Swiss company. So there was a significant concern that if something wasn't agreed to before the sale went through, the Canadian government might have a much weaker hand in managing the process. And basically where we're at now, the governance body is up and running. It has 18 members, 6 from the Ktunaxa Nation, 1 each from the tribes that make up the nation, 6 from Canada and British Columbia, and 6 from the United States, 4 US representatives and a representative each from Montana and Idaho. And I think this is another big win for us, because the tribes and the US representatives, we're all on the same page. We all want the same thing. So I think we have a pretty strong hand on the governance body. The study board was supposed to be stood up by September 6th of this year. Last I checked, that had not occurred. It may have in the last week or so, but I haven't heard. And there's been some foot dragging. British Columbia has been a little less excited about moving forward on this than we might hope, but the effort is ongoing and the IJC is working hard with everybody involved. So a couple of takeaways: years of work ahead. Success will depend on the ability to facilitate cooperation between US, Canada, BC, and now Glencore. And two questions come up. Well, one question comes up: can we leverage this kind of success or this kind of process to work on other challenges or in other watersheds throughout the West? Here we're talking about kind of, at least in the Elk River, we're talking about putting toothpaste back in a tube. We've got more than a century of mining pollution. We have more than a century of infrastructure in the ground and impacts that are really hard to undo. But that's not the case everywhere we go. If we move west one watershed, we move over towards the Copper Mountain mine. This is in the Similkameen watershed. This is a proposed upgrade to a Canadian mine there. This is more, well, the toothpaste isn't out of the tube, but the cap is off and the risk is there. This is a mine that produces gold. It's been in operation for over 50 years. And the state, or the EPA, the State Department, the White House, tribes, First Nations, they're all very concerned about this. This is the existing mine operation here. Like the other, in this case, it's a gold mine. As with the slide we started with, it has a large tailing pond. So the tailings, the water, the chemical runoff, the byproducts of the mining and processing process, they end up in this reservoir. This is a valley. The reservoir is held back by earthen dams at both ends of the valley. And Hudbay Resources, that owns this mine, wants to, what I wanted to say is expand it, but what British Columbia considers an upgrade. And that's a really important distinction, because what Hudbay is proposing to do is not expand the perimeter of the mine, but to go in and remine areas that have previously been disturbed, areas that were first mined back in the 1970s. Because of that, the province of British Columbia concluded that they do not need to do an environmental assessment on this mine, so the equivalent of an environmental impact statement that we would have in the US. What they will do is mine, this, I think it's this area, I'm a little twisted around on the orientation. So there'd be more mining, and it would require an enlargement of this tailings dam. So it would raise this dam by about 60 feet. I don't know if you can see the vehicles on the top of the dam there for scale, but it would make this one of the largest, if not the single largest, wet tailings pond in the world. Which is a big deal because, again, we're talking about a tributary to the Columbia system. A breach of this dam, a breach that released 40% of the reservoir contents, would essentially cause a tidal wave by the time it hit the Columbia River. It would wipe out infrastructure, and it would have a tremendous negative impact on water quality, on salmon, on cultures, on hydropower, on everything that's dependent downstream. As I say, British Columbia decided an environmental assessment was not necessary because there's no real expansion of the footprint here, and most of the pond expansion will occur in previously disturbed areas. So the question then is, how does the United States engage on this? How do tribes and First Nations engage? How do they work with Canada to make sure that this decision is made as responsibly as possible? And if we move farther north and west, we move up into southeast Alaska, we run into kind of an area where now the cap is on the tube of toothpaste, but there's a lot of interest in mining up here. What you're seeing here, and this is a little dated, this is a map from about 2 years ago, but we're looking at transboundary watersheds again. So whatever happens, whether it's on the US or Canadian side of the border in these watersheds, it's all going to drain downstream into the United States. The kind of gold or mustard colored stuff, these are prior mining activities. The green dots are the really big, large current operations. But if we zoom in here, And I should say this is roughly where Juneau, Alaska is, right in here. If we zoom into these watersheds, the Stikine, the Iskut, the Unuk, the Taku, that are just above Juneau, we see tremendous interest in mine expansion there. This is about a two-year-old map, so it's not very accurate anymore. The purple spots here, those show Canadian mine tenure. So that's land that the British Columbia government and the Crown has agreed to convey to mining interests, or as conveyed away mining claims. The black dots are operating mines. The white dots are proposed mines, and I think there are 2 or 3 more very large mines proposed in the watershed at this point. This purple extends to include almost all of the Iskut, the majority of the Stikine, and then if you move over into the Taku, it's pretty well purple at this point as well. So there's a tremendous interest in expanding mine operations in those watersheds. That has the potential to have huge impacts downstream on the U.S., in Juneau and on the Alaskan salmon fishery throughout the Inside Passage here. So it has the potential to have very wide-ranging impacts. And again, the question is, how can the United States, how can tribes and First Nations engage effectively with the province of British Columbia and with Canada on these mine expansions? I have a letter here from Senator Murkowski and the Alaska delegation. It was sent to the president back in August. This is the most recent of a series of letters where the delegation is really pushing on the administration to say, we have a profound concern. We're very worried. We're very worried about water quality. We're concerned about cultural impacts and impacts on salmon, and we want you to act. So there's a lot of pressure being brought to bear within agencies that are concerned, from the Alaska delegation, from tribes and First Nations, and again, how do we move the needle on this? One of the things that Senator Murkowski and a delegation are proposing are limits on federal funding or the expenditure of U.S. dollars on mines in British Columbia. So as you may be aware, there's a demand for critical minerals, lithium, cobalt, things like that go into the green energy transition. And Senator Murkowski is saying, wait a minute, let's not necessarily put U.S. funds into mines in British Columbia unless they agree to meet standards, operating standards, or water quality standards that are comparable to those that we have in place in the United States. Let's not invest those funds, whether it's through the Defense Production Act or elsewhere, unless we can show that those mining companies are designing their tailings ponds in ways that don't pose a huge risk to the United States and to downstream tribes. So that's kind of the question moving forward. And the exciting part of this for you, for the students in the room, is that Professor Morrison, as some of you may know, will be starting an international law clinic next semester. So it's a pilot. I think it's only going to have 6 students. But Jackie came to myself, to Professor Jamie Plune. We all sat down, and Jackie's question is, do you guys have any international problems that we might be able to work on? And we sat down and we talked, and we said, well, yeah, as a matter of fact, there are a couple of things going on in British Columbia that pose concern to the United States, that pose concerns to tribes, and we've got some partners that might be willing to work with you. So we had conversations yesterday between the law school, the Confederated Salish and Kootenai tribes in Montana, and the Tlingit Haida up in Juneau, Alaska. They have tentatively agreed to be partners with us on the International Law Clinic next semester. And if all goes well, we will have an opportunity to work with students on these kinds of international mining questions, how the United States, how tribal entities can gain a voice in actions that occur in British Columbia. So I'll stop there, and if there are questions, I'm happy to answer those at this point.
Thank you, John. I've got a cue here, and I said it was if you go to slido.com, it's hashtag CEQ. Hashtag CEQ. But let me just head up the queue. The one that has the most upvotes to start. You mentioned your role in helping designated monuments. Do you have any thoughts from your experience that might shed some light on the controversies of designating other monuments, particularly those in Utah like Bears Ears?
Let me preface this by saying that I was fortunate to work on the original Bears Ears National Monument and around some of the litigation. So when I went to CEQ, we treated that as a conflict. It wasn't necessarily a conflict under the law, but we were very concerned about the perception of a conflict of interest. So I had a firewall. I didn't work on anything involving either the Grand Staircase or Bears Ears. I think, I've said a lot about Bears Ears over the years before I went to CEQ, so I think I can kind of pick up on that. I think Utah's case challenging the reductions of Utah's case supporting the reductions and then challenging the reinstatement of those monuments will be very, very difficult. The language in the Antiquities Act that authorizes the president to designate national monuments it breathes of discretion. It requires that the president identify objects of historic or scientific interest, that they exist on land that's either federally owned or controlled, and that the president determine that the boundary is small enough to protect those objects. That's it. It doesn't define objects. It doesn't go into tremendous detail about what that boundary might look like. So there's a ton of discretion, and the Supreme Court historically has been pretty deferential, and appellate courts as well have been pretty deferential to the president in determinations of what classifies as an object. If any of you read the Capert decision, that involved a fish in a pond inside a national monument. So we know that at least the Supreme Court in that context was comfortable with fish and wildlife. There are opinions out of the DC circuit that talk about landscapes, talk about ecological features that are also very deferential to the president on those issues. And I think in the end, to succeed, Utah would need to basically say, look, within the boundaries of this monument, whether it's Bears Ears or something new that might be designated moving forward, they'd need to be able to say, look, there is a chunk of ground that doesn't contain resources of historic or scientific interest. That's not necessary to protect those. And I think that's a very, very difficult claim to prove a negative. I mean, it's not just a matter of saying, all right, here we have a kiva, or here we have ancestral Puebloan dwellings. You can have those, but simply protecting the structure themselves isn't enough. If you're standing in those cliff dwellings and you're looking out over McDonald's, or you're looking out over an oil field, you've lost the context. You've lost the meaning of that landscape. So I think that's going to be a very difficult thing for the state to bring forward as a viable legal claim.
Thanks. Let me give you these two, and you can answer them in the order you determine. So first one, you mentioned that CEQ frequently gets things done through soft power. Can you say more about that? And then the second question, What advice would you give students who want to work in environmental resource or or energy law in the government?
Okay. By soft power, essentially, what I was trying to say is that CEQ is not a regulatory agency. It's not like the EPA. They don't issue permits to discharge, pollutants into the air or into the water. They don't have the ability to say no. They don't have a hammer behind them to say that, permittee, you are in non-compliance with your permit and then take an enforcement action. So that means, aside from promulgating regulations, the procedural regulations that implement NEPA, the role is more of as a convener. It's more an ability to bring agencies and stakeholders together and bring attention, public attention sometimes, to bear on those issues. So it's a different way of trying to get to the end, maybe using more diplomacy rather than going straight to court. CEQ, that the Office of General Counsel, to the extent that we ever were involved in litigation, it was as a defendant in challenges to the regulations themselves, rather than as going out and trying to enforce things. And then as students that are interested, how to get involved.
Yeah. So again, what advice would you give students who want to work in environmental resource or energy law in the government?
Well, I think you're in a phenomenal place to do that. I think you've got great instructors. Get to know them. Take advantage, if you can, of internships, externships, opportunities to get to know agency staff or people that work in industry, people that work in the legal community representing these clients. That's the best way to get the job, is to know the people, build the relationships, and kind of work your way in. To the extent that you have an opportunity to go to DC, I highly, highly, highly encourage it. Even if it's only for a semester, it's a tremendous way to build connections, build relationships, to see how the process works and how decisions go from the text of a statute to implementation and decisions on the ground. And I think it's really a valuable experience.
Great. So next question is, this might come from your insights at CEQ, conversations that folks had there that we're not all privy to. What is the most important environmental issue that nobody seems to be talking about? Is there a sleeper issue that deserves more of our attention?
That's a great question. I think the one theme that runs through everything that we touched, whether it was questions about permitting for solar development, wind development, electric transmission, oil and gas development, what's going on up in Canada, the common theme is the lack of agency capacity or constrained agency resources. And this is, I can't say strongly enough how big a problem this is. I don't know if any of you noticed, but it was 2 weeks ago, the Forest Service said they have stopped hiring external candidates. They are no longer going to hire seasonal employees except to fight fires because they don't have the budget. We see similar concerns through just about every federal agency. The assistant administrator of the EPA was hauled in front of Congress earlier this year and testified that, yeah, we are not meeting our obligations under the Toxic Substances Control Act because we simply don't have the resources. If you don't have butts in seats, you're not going to have anyone that can act on a permit application. So if you're in industry and you want swift action, you've got to have somebody there to do the work. If you go back and you look at what causes permitting decisions to bog down, the Government Accountability Office looked at that very specifically with respect to large mines, hard rock mines on federal land. First problem, poor quality applications or incomplete materials coming in from mining proponents. Number two, nobody or inadequate people in the office and inadequate technical resources to work with those applications. Number three, changes in those applications that occurred midstream after the application had already been submitted that required the agency to go back and redo its work. Number four was permitting complexity. And number five was poor quality work coming from consultants that were brought in to do the work that the agency couldn't do itself. So when I look at that, I think if we want to make government work better, whatever that means, if we're trying to get more electric transmission, more green energy, or frankly, if you want to have more natural gas out there, you need to have people do the work, not just because it gets the permits processed faster and better, but because it gets to almost every one of those other five problems. If you've got poor quality applications coming in, how do you fix that? By having the agency sit down with the proponent, clarify expectations, work with them to make sure those materials coming in are adequate, to make sure that they don't have to change the plan of operations halfway through, to work with the consultants to make sure they understand the expectations, to make sure that they are producing the product that agencies need. So I think if I had a magic wand and I could fix one thing, it would be making sure that agencies have the ability to do what they want. And I know I'm kind of on a rant on this, but I want to make one other point that I think brings it home. At the beginning of the Biden administration, I was talking with an individual, I'm not going to say who they are, but a high-ranking individual in the Department of Interior. Good friend, longtime colleague, and I was giving this person a really bad time. A senior official in the Bureau of Land Management. I said, what the hell are you guys doing? Do you have any idea how many open jobs you have? What are you doing? Why aren't you hiring people? Why aren't you filling jobs? And I think my friend got fed up with me. And they said, John, you don't get it. It's not just that we lost 60% of senior management. It's that we lost our human resources department. I can't hire until we build back the capacity to process applications and to go through the hiring process. And that really struck me. I mean, that's, we get the government we invest in, and we have underinvested for a very long time. And I think that, regardless of where you fall on the political spectrum, whether you're concerned about Secret Service protection for presidential candidates, or you're worried about permitting efficacy, or you're worried about protecting water quality, we just have to do better on that front. So sorry, that was a bit of a rant.
John, this will be the last one. You've got 1 minute. This is a lot.
Okay.
Agencies often get criticized for being too political, whether they're Republican or Democrat as a president. Conservatives increasingly criticize government career employees as the swamp. From your time in service, how much merit is there to these sorts of critiques?
Very little. And obviously that's what I have to say, right? But honestly, I didn't see that. the laws exist. The laws are the same regardless of whether you're a Republican or a Democrat. You're working under the same expectations. You're implementing the same legal structures. You go in assuming you're going to be challenged on just about everything. You assume that litigation is likely to occur. You assume that FOIA requests are likely to come in, and you dot your I's, you cross your T's. It's just that simple. There may be slightly different prioritization across within an agency depending on the administration that's in charge, but most of the people, definitely almost all of the career civil servants, they are very careful and very diligent about implementing the law. You had some people like me that are in there to push and change some priorities a little bit. But again, I didn't see it happening. And part of it too was, at least under the Biden administration, there was a very, very significant emphasis on ethics. I had to sign a very long ethics pledge. Probably once a month we had trainings on ethics or some other aspect of document management or related to the decision-making process. I know I'm way over a minute, but I'm gonna continue rolling because you're a captive audience. There was so much thought and concern that went into protecting the legitimacy of government and legitimacy of the agencies and the institutions. It was really, really profound. Last story, and I'll stop. But probably once a month over the last year, we had discussions. And when I say we, I'm talking about everybody was in CEQ on an all-staff call talking about the election, and the direction was clear. You cannot talk politics. You cannot talk it in the office. You cannot talk it in your professional capacity. You cannot so much as have a coffee cup that says, Biden-Harris on your desk. It cannot be visible. If you have a Biden-Harris campaign, a bumper sticker on your car or a MAGA bumper sticker, you can't park in a federal parking lot. That was kind of the level of direction that we had, that we didn't cross those lines. It's not to say people didn't care, but I would push back and at least say from my experience, the people I worked with were by and large institutionalists that wanted to protect the integrity and the viability and the productivity of those agencies, and they did just about everything they could to make that happen.
Thank you, John. This is all for today. We look forward to seeing you back here on November 7th, where our annual Young Scholar Joshua Macy will address us. Thanks.